The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting in diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, all right, good afternoon to both of you. Again, I want to introduce myself. My name is Ariane Vuono. I'm an Associate Justice of the Appeals Court in Massachusetts, and this month I'm designated to hear matters that arise from the various trial courts, including the matter that's before me now, which is, as I understand it, an appeal from an order of use and occupancy payments entered by a judge of the Housing Court. So the case number is Single Justice number 2021-0392, if I'm not mistaken. Clerk Cutting, am I correct on the number of the case? I think that's it. If not, we'll correct it later. All right, so I want to just say a couple of things before we start, and that is you each have 15 minutes to present your argument to me. You can use less time if you would like, and I will let you know that I won't cut you off if you have some additional things you want to say to me. Ms. Booth-Desmarais, did I pronounce that correctly?
You did, Your Honor.
Okay, you are going to be going first because this is your appeal. And after you give me your, make your argument, then we'll hear from the attorney representing the plaintiff, which is Ms. Langevin, or Langevin, if I'm pronouncing it correctly. And then you don't have the opportunity to speak again. You had to tell me everything you want me to know at the beginning, when you have your time to speak. Okay, that's how our rules work. That's number one. The other thing I want to mention just briefly is that you know, we're on Zoom. I know you've both been on Zoom before, and during the past year in the pandemic have been operating in this procedure. We're very fortunate that we can do that, and we can stay safe and be able to move our court procedures along. Upon occasion, there's some difficulties. If so, just be patient. We'll get back on, and I'm sure it will all work out. All right, so with that being said, my understanding of this case, Ms. Booth-Desmarais, is the following, that for a period of time, you were paying use and occupancy payments in the amount of $775 per month, which was an amount that had been previously agreed upon between yourself and the plaintiff. And that thereafter, as a result of the plaintiff's motion, the amount was changed. And the court has now ordered, beginning September 1, that you pay $1,175 per month. And that's the order that you're appealing from. Do I have that correctly? Am I correct?
Your Honor, I don't know if this is relevant, but it was, it started at $625. It was changed last year to $775 between Ms. Langevin and myself, and now it is currently trying to be changed again.
Okay, well, thank you for that clarification. But just to be clear, what you are challenging right now is the use and occupancy amount in $1,150.
Yes.
So why don't you go ahead and tell me why you think that that's inappropriate? I'm going to just use my own timer here to keep track of the time. Okay.
Well, thank you, Your Honor, for seeing us. The reason that I believe that I had to appeal this is the increase was based on a realtor that had not ever been in this property to see all the code violations, the toxic living conditions, etc. She based her opinion solely online and rental properties in my area. She is a realtor that I'm told that's from the area, which is great, but she has never been on the property. Miss Langevin's original realtor, his name's David something, but I can't remember, to be honest, what it was here when she had put the house on the market originally during COVID. And the last time he was here, it was pouring out. There's a lot of water leakage and the house retains a ton of water. And as he left, he stated, and I quote, "The house is not sellable at this time." So that's the first thing. Increasing my rent at this time, as you had stated, the rent was $775. It's to be increased as of September 1st with no later than September 5th to be paid. I'm currently paid, Your Honor, just for the record, until October. So my next payment would actually go towards my November rent. I think that's something that you need to know. Increasing my rent at this time.
Well, let me
would
just interrupt you for a second. So as I read the court's order, what's going to be in place is that the court says that as of September 1, there would be that increase. And you're indicating that you've prepaid through September and October. Did I hear you correctly?
Yes, that has been, it's been prepaid forever. Council would know that it's in the records. I literally filed every check that I
No,
have.
yeah,
given her.
I'm not done that. I just want to be sure that for September and October, then you've paid the amount of $775, not the
I am-
higher amount. Is that
I
correct?
am already paid, yes, until October. So like my last payment was for October, yes.
And that was an amount of $775, 770. Okay, all right.
Yes.
So I want to be clear that you understand now that or in place now that I'm going to review is an order that requires you to pay a little bit more for those 2 months. So I don't want you to be. I'm going to, of course, review this. I review this de novo. I'll determine what's appropriate. But
Yes, I've been
right
paid
now,
ahead of
September
time.
1. So you're also asking for any change, if there should be a change, to not begin to November 1. That's the second thing you're asking for. Is that correct?
Yes, yes.
All right.
Because I've already paid.
I know. I understand. This,
Okay. All right. I'm sorry. I forgot where I was.
no, that's okay. You were talking. Yeah.
Increasing my rent at this time would change our legal agreement, I believe, to which I've consistently paid my rent every month, Your Honor. It's been on time, despite Miss Langevin's refusal to fix anything. I've consistently still paid. I was told I could hold my rent. I have never done that. Counsel will tell you that in the hearing, that is in fact true. There's no dispute on that whatsoever on either side. I've never not paid my rent. I understand right now many people can't and haven't. That is not the case here. I have always paid it in its full amount and on time.
So is it your position that the amount of 1,175 that's not what the property could be rented for? That's not the fair rental value of the property. Is that correct?
Your Honor, I understand that since COVID, rental properties have gone up a great deal. However, this property, I literally had a housing inspector here yesterday, and although she doesn't have her report written up formally yet, she said it would be forthcoming. She has listed numerous issues that are not up to code, what she could not. So the way she explained it to me, Your Honor, because I've never done this before, and I had called before, but I guess she not only does Millbury, which is the town in which I reside, but she also does Shrewsbury. So like we had a sewage leak downstairs. There was literally sewage, feces, all downstairs in my bathroom and seeping out. And Miss Langevin's comment to me when I had a plumber on the phone with me that was willing to come over that minute and take care of it was, that's too much money. We're not dealing with it. Get a shop vac and clean it up. The plumber finally came 5 days later and did fix the problem because of course you got to order parts and such. He said that this is an extreme health hazard and gave me a number to give to Miss Langevin if a proper person, because he saw my buckets of bleach that I've used to clean down there. And he's like, A, you should have never done that. That is extremely dangerous to your health. He's like, and B, you need a professional in here, because he lifted up the tarp under the floor because none of it's sealed. And he's like, all the feces matter went all underneath here. And it's all in the, what is that stuff called? Insulation.
Yeah.
It's in the baseboards, it's in the wood, it's in everything. Miss Langevin's well aware of this. We have text messages going back and forth. She had literally done nothing about it. And then I'm assuming when she got my appeal for this and knew that we were going to have a session, she automatically started texting me, she won't fix the refrigerator. She told me that wasn't her problem, even though it came with the property. And now, since she's gotten this and known it was coming, now she has texted me at least about the refrigerator and said, I'm working on it. And it's,
Well, what is the status of the cleanup with respect to the sewage spillage right now?
as of 2 weeks ago, when I spoke to the individual that the plumber gave me the reference to, he had said he had never heard from the Candace Langevin.
Okay, so it's not been remedied, is your point?
Your Honor, the only remedy there has been is what I could possibly do to put millions of buckets of bleach down there to clean it up. She refused to do anything about it.
Now, I just want to make sure that I understand that that the issue of the sewage spillage, for example, was an issue that was brought up before the housing court judge. Am I right about that? Did you bring that up? Did you bring it up at that time?
May 18th, it happened, and I believe the last time we were in court, Lord, was that before that or after that?
Well, there's an order here issued August 9th.
After that. It was after that, because we were seen on 8/11, so the sewage spill was after that, Your Honor.
Was after August 11th?
Yes, yes, it was. No, I'm sorry. What am I saying?
That's all right. Just take that's all right. We'll just.
I know, but I got a timer going and I really need.
No. You don't have to worry about the timer. I'm taking care of the time. All right. You don't have to worry about that.
I know, but I don't want to run out of time. It's so important that you understand everything that's going on.
Well, be assured that I've read everything is in the docket. I read your statement about the sewage situation that you provided. So I have reviewed that.
Oh, so you do have it. Okay, great.
Yes, I do. I have access to all the documents, and I have.
Yeah, so I believe it happened on May 18th, Your Honor. I like this text is, get a spray bottle of bleach and, clean it up yourself. Go get hydrogen peroxide and.
So just back up for a moment. What was unclear to me, and that's what I'm trying to find out now, is whether or not the Associate Justice of the Housing Court, Judge Kelleher, who heard this case, who issued the order, which is dated August 9th, whether or not the problems with the property, including the sewage spillage that you are now telling me about, was that ever brought to his attention or not?
Your Honor, I don't know if counsel can tell you or not, but I have memory issues as part of my disability.
Okay. All right. So you're not sure. That's fine.
I can't answer that question.
Okay.
I would.
Right. Okay.
I do recall the judge. I do recall the judge saying to me, Ms. Booth-Desmarais, please remember that I've been here from the beginning, so we don't have to go over everything.
Right.
And I
You
went.
mentioned that in your statement.
Yes. Yeah, so I was like, okay, so I didn't, because I don't want to waste his time. And then it's like, I don't know how you could possibly state to pay more when you have all this information. It just doesn't make sense.
Let me summarize things for a little, if I may, for a minute, because you're doing fine, but you're getting close to your time. And there's that you believe your position is that the amount of $1,175 per month is unreasonable given the current condition of the house, that there was a sewage spillage, and there's other issues that have been raised, in particular issues that have been raised by an inspection that just happened, right? So you think that the amount of money per month, I'm going to use the term excessive. It's too much given the condition of the house. Have I summarized your position on that?
Yes, Your Honor, as well as the fact, and I don't know if legally this matters or not, that I have a $1,500 a month pay cut. So now there's
yes, that does matter. That isn't that. Okay, I'm going to turn off the timer now. 1 second, excuse me. All right. So we're getting close to your time now. Yes, there's a number of factors that are to be considered with respect to the validity of a use and occupancy payment. And one of them is, for example, whether or not you've had to pay out of pocket for repairs. Another issue is the condition of the home. We've talked about both of those things. Another issue is whether or not there is an inspection report or photographs that show the conditions. And you're saying to me that there is a report that's not been finalized, and I'm going to presume that that has not been given yet to opposing counsel, that he has not seen that report.
No, ma'am, it was literally yesterday, so I couldn't
Okay.
give it to
All
him.
right.
And this is just a baseline, like she said, she's on vacation for the next 3 days, so it will be forthcoming from a week from the time she gets back. I guess that's how long she has to write a report. And then she said a certified copy will be sent to Miss Langevin as well as a regular copy. And so she'll have it in her possession as well.
All right, so let me ask you this. So you believe that this report will be finalized in about 2 weeks or so, is that correct?
Yes, she said to give it a reasonable amount of time.
Okay, so I'm
never done one
gonna
before.
address this with counsel for the plaintiff about whether or not we should wait to see that report. So just we'll hold that off for a second. The other thing is, of course, that we do consider is the amount of rent that is due, and everyone agrees you've paid, so we don't have to worry. That's not really a concern here. And the other issue is your current economic situation. So you've now had a reduction in your a monthly income by about
Yes.
$1,000. Okay. And how did that come about? Why has that been reduced?
$1,500 a month less. It was like $1,548 or something. Because my son that has gone off to college no longer gets his dad's death benefits. So
Okay.
he still lives at home. He's commuting because he wanted to stay at home. Because if you don't know, that the woman that is Miss Langevin is my biological mother, their grandmother. So this is very upsetting all around. And my son did not want to be away from.
Okay, just take your time, take a breath. So he's staying with you now, right?
Yeah.
Okay, all right. And he's going to be able to attend college starting in September?
We don't know how he's going to get through because now I don't have the income to help him, but he's doing it. He's enrolled and he's going to his orientation on Saturday. And he starts
Great.
August
So now
30th.
where's he going to go? Where's he going to school?
Assumption College in Worcester.
Okay.
He's going to be a history teacher.
All right.
With a minor in psychology. Yep.
Okay. All right. Okay. So that's where things stand now. All right. So is there anything
And then my
else you want-
baby's still home.
Okay. All right. Is there, are you employed at all? Are you doing, okay, so you stand, all right. So that's the situation with respect to your monthly income. Thank you for explaining that to me. I think I understand everything that you have brought to my attention. I don't have any more questions. Is there anything else you want to tell me before I turn now and hear from plaintiff's counsel?
Just real quick, Your Honor, I feel as though if counsel is trying to get the court to increase my rent, then that it will cut off my attempt at my legal right to an appeal, which has already been sent to you guys, but because of the backup with everything that's happening with everybody, I have not gotten my transcripts yet.
But you have ordered them. You were.
Oh gosh, yeah.
All right.
Yes, ma'am. I'm waiting for them and have been for quite some time. But I mean, honestly, this is a lot of stress. And if I could have been out of this house, I would have been. But my baby, I have no place to go. The rents are astronomical. I can not afford a home on my own. And I did offer to purchase this one, but because now Miss Langevin thinks that she's going to get so much more money, which in this crazy market, she might as well. Money's been more important to her than her family. And I uprooted my family to move here to help her when I was very well established elsewhere. And that's where I had wanted and intended to stay. But again, I tried to step up to the plate and do the right thing by family. And this is, Your Honor, unfortunately, where that good intent has gotten me and my children.
All right. So the last thing I want to say is that I am noting that in the judge's order, he notes that there was what they call no counterclaims regarding the conditions of the premises. So that leads me to believe that he was not made aware of the issues that you're bringing to my attention now. but I'll clarify that with the attorney, okay?
Yeah, Miss Langevin's known about them. She got an
Okay,
insurance
I
payout. She
understand,
knows.
and now you have a report done, so we'll go from there. Well, okay, so I'm gonna have you just stay here. You have to listen carefully to what is being said by opposing counsel, just as he has carefully listened to what you and I have talked about, okay? All right, so I'm gonna turn now to attorney to help me out now. Say it for me one more time, sir.
Vuono, Your Honor.
Vuono, okay. Good afternoon.
Good afternoon. May it please the court, Tom Vuono for Candace Langevin.
I'm just going to start your timer as well. Here I go. Go ahead.
Thank you. Good afternoon. May it please the court, Tom Vuono for Candace Langevin, landlord, appellee, plaintiff in this matter before you. Unfortunately, I was not the trial counsel, so unfortunately I can't give you insight as to what happened at the trial. I was retained probably sometime in June or so. But my understanding in speaking with prior counsel, my client reviewing the docket, the case transpired on a 30-day no-fault notice. Trial and judgment entered in February, as Your Honor pointed out. In the findings, there was notation that no counterclaims or answer were filed. I'm not sure what was raised during the trial, but certainly if Ms. Booth would have raised some things, I can assure you that she wouldn't be bound by not filing it, and it would have been addressed in the ruling.
What I'm understanding, attorney, is that the issue with the seepage of the sewage happened afterwards. And then, of course, as you've just heard probably for the first time now, there's been an inspection. So and maybe you could address that. I'm sure you haven't been privy to that report and you haven't seen anything, right? No. Right. It seems to me, since that's one of the factors that should be considered, that one possibility here, I'd like to get your view on this, is to simply, wait another 2 weeks or so until that report can be submitted, so you can review it, and then it could be submitted to me. Do you have any opposition to that, or what is your position?
I think I would have to oppose that, Your Honor. My position, and with all due respect to Ms. Booth-Desmarais, is financial constraints. My client is also suffering financially, and that was the reason for filing this motion for a status update on the progress of the appeal. She lives in Florida. As you can see from the rulings at trial, there was a breakdown in the agreement in terms of the family. My client had previously been able to reside at the house. Something happened and she was no longer welcome to stay there. My client recently, and I think she's on YouTube, but I told her this was an evidentiary hearing, so it's
correct. This is not an evidentiary hearing. You're absolutely correct.
She did tell me that there is a family member with some health issues. She would like to come up and help and stay in Massachusetts, but she can't afford to pay rent from somewhere and then also keep the house going with the costs. I think it's, before I get to the sewage issue, Your Honor, I think it's important to note that the initial order regarding the waiver of the appeal bond and the use and occupancy payments from March 19th, there was mention that there was no evidence presented regarding the monthly operating expenses of the property. And accordingly, the $775 a month was the agreed upon monthly amount between the parties, and that was chosen. I understand because of COVID, everything has been backed up and delayed, but she nevertheless took no action on her appeal until after I was retained and filed a motion back in June, I believe, to either dismiss the appeal, and then at that point she ordered the transcript. So 2 months went by with nothing happening. This issue of the sewage in May, we had our hearing on August 4th. I filed and served this motion July 15th. This is the first time I'm hearing anything about this, but even if you credit everything she says by her own words, she indicates that it was repaired. And she tells you what my client confirms to me, that a plumber timely appeared, and it took several days for this some ejector pump to be ordered, some part, and then that was repaired. And so my client did repair that. In contrast to the hearing that led to the March use and occupancy order, the hearing in August featured my client testifying to her carrying costs, which is consistent with the rulings at trial. They increased from $1,100 to $1,175. So it's not like she's doubling the costs, but she also produced a fair rental value of the property from a real estate professional in the amount of $1,700 to $1,850 a month. So even if there are these conditions existing at the property, Ms. Booth-Desmarais is nevertheless still getting a if my math is correct, $525 to $675 discount on what the fair price would be for this property. So if indeed, I don't even know what these code violations are, but if indeed they are serious, my client certainly is given time, whether it's 24 hours, 7 days, or 30 days to repair them. If they're not repaired, then certainly the town can take action against her, or Ms. Booth-Desmarais can take action and try to revisit this issue with the court. But as of now, I don't believe that there's anything before you that suggests that coming off of the $1,175 a month would be appropriate. Judge Kelleher, both in March and in August, used all of the factors, considered both parties' financial circumstances, in addition to the property, any issues with the property, and none were raised. None were raised, even though the hearing was in August and this issue with the sewage in May had supposedly happened. So there was full and fair opportunity for anything to be raised at that point and any claim to be heard, but none was presented.
Okay. What do you have to say about another issue that was raised, and that is Ms. Booth-Desmarais alleges that she has prepaid through September and October.
This is the first I'm hearing of it.
Okay.
Don't, if indeed that, I can confirm with my client after the hearing, if indeed that is the case, then certainly she's entitled to credit for that. And I would only seek the difference between the order that was imposed versus the $775 that she says she paid. I'm sure it's easy enough to confirm with records from my client.
Sure. All right, that's fine. If you haven't come up today, you didn't have the opportunity to check that, so I understand.
This is the first time I'm hearing of it.
All right, well, that's why I wanted to be clear that this particular order that's before me does indicate September 1, so there's no confusion about that. All right, and I also understand that there was no competing evidence presented with respect to the fair market value of the property.
No, Your Honor.
There was just the one submission by the real estate agent that was provided by your client, correct?
Yes, Your Honor.
Okay. All right. Well, is there anything else that you want me to know before I take this case under advisement?
Just very briefly, as Your Honor is well aware, under 239(5)(c), the purpose of the payment is to pay for all rent that's been accrued, and she has paid all the rent, so that would be zero. But it would encompass all intervening rent plus all damage and loss, which my client would suffer until a final appeal is heard, and that could and will be some time from now. So based on that, I think the order is appropriate, as it adds to the agreed upon rent a fraction of the, in addition to supplement my client so she can maintain her carrying costs. She's certainly not making a profit on this, and she's just breaking even. So, is there any dispute from your end about the fact that the defendant here has her monthly income has decreased? I have no evidence, and I have no reason to dispute that. The judge found that, and there was no dispute as far as you know. Okay, all right. Well, I want to thank both of you for explaining everything to me in detail. I appreciate it. And what we do now is, and as the attorney knows, but I want you to know, Ms. Booth-Desmarais, that I take the case under advisement. I will give you an answer very soon. If I determine that I want to see the inspection report, as I said, I will let all the parties know.
But you will be hearing something from me in the very near future. All right. September 1 is coming up quickly, so I'll do my best to be sure that you know whether or not, one, we're going to wait for the report, or two, whether or not I'm going to go ahead and make a decision with respect to what the appropriate use and occupancy payment will be. Okay. All right. Thank you both very much. In cases, I'm now under advisement.
Thank you, Your Honor.